Okay. So, hello everyone. Thank you for joining us for this very interesting topic. And I would like to welcome all our panelists who have taken the time to present this conference for all of us on the topic ADR and the Vanishing Trial, the growth and impact of ADR. So, yes, so I can see attendees have joined in also. Thank you so much. World Law Alliance has organized this virtual conference for all the arbitrators and mediators enthusiasts who are really interested in the subject. And we are also streaming this live on our YouTube and World Law Alliance LinkedIn channels. So you can also watch this live stream there. So yes, now I would like to begin with the introduction of our esteemed panelists who have joined us here. We have Ms. Ananya. She's a principal associate in the dispute resolution practice of a very renowned firm. She's a member of the firm's international arbitration team. So that's Ms. Ananya Aggarwal for you all. Ms. Ananya, I'll kindly request you to say hi and hello, address our audience. Yeah.
Hi, everyone. A very good evening, afternoon, wherever in the world you are. And I'm really excited to be a part of this very esteemed panel and to share my thoughts alongside such renowned people. And I hope you all find it very interesting. And, we have a lot of questions coming in. So I look forward to it.
Thank you, Ms. Ananya. It's our pleasure to have you on the show. Next, we have Ms. Athina. She is an internationally recognized arbitration expert and independent arbitrator. She's based in Paris. So, hi, Ms. Athina. Happy to have you here.
Hello, thank you very much for having me. I look forward to our discussion.
Thank you so much. We have Mr. Giovanni with us. Hi, Mr. Giovanni. He's the co-owner and president and senior partner of the Techno Engineering and Associates Group, an international techno-legal consulting engineering firm specializing in contracts management, construction law, claims and dispute resolution internationally with offices in Romania, Bulgaria, Qatar, and Kuwait. So, hi, Mr. Giovanni. Can you please unmute and address all of us? Yeah, we are really happy to have you here.
Thank you very much. I'm very happy to be part of this panel, and I look forward to the very interesting discussions that will follow.
Thank you, Mr. Giovanni. Definitely our pleasure. We have Ms. Veerash with us. She's an admitted advocate, practicing mediator, and the director of Fair Practice, a dispute resolution services organization based in Johannesburg, South Africa.
Hello, everybody, and thank you very much to World Law Alliance for this opportunity to be here today. I am grateful for being part of this illustrious panel, and I look forward to the discussions.
Thank you so much, ma'am. Lovely to have you here with us. We have Ms. Praveen with us. She's a professor. She has spent several years as a commercial litigation lawyer in Vancouver, Canada, with a drive for keeping parties out of court. In 2021, she founded an international mediation and arbitration practice. And I think that's really commendable. Yeah. Ms.
Thank you so much for that introduction, and thank you for having me here. Greetings to everyone from Vancouver, Canada. I look forward to our discussion here today.
Great. So thank you all of you for introducing yourselves and maybe, addressing our audiences. Lovely panel of speakers we have today. So I think without any further ado, we should proceed with our topic. So I would like to ask Ms. Athina to share her views on the topic ADR and the Vanishing Trial, the growth and impact of ADR. Ms. Athina, would you like to take this further? and educate our audience. Yeah.
Thank you very much for this, and thank you very much for the question, which is quite pertinent, quite timely. We see effectively the scope of alternative dispute resolution widening, covering a dispute, and I'm speaking about arbitration specifically, which is my field, for example. Arbitration has become more generalized use. Perhaps 20 years ago or 30 years ago, it was a dispute resolution mode restricted to big disputes between international companies. And what we see now is that more medium, small-sized companies will resort to arbitration when the need arises. Moving away from the field of arbitration, just to discuss about other alternative dispute methods, we see again that even smaller enterprises welcome mediation, and they don't see resort to courts as the only alternative to a negotiated settlement, the classic way, let's say. No, now does this mean a vanishing trial? We will discuss about this, and I would be very happy to have the views of the other panelists. In my view, the court trial is here to stay. By all means, is a system that works in general, that has worked for years in several jurisdictions. But the good thing about all the other alternative methods that we have is that it is possible to tailor-make the dispute resolution. It is possible to go for a method that suits the particular characteristics of the parties of the dispute itself and the particular needs of the parties in dispute. And I would be very happy to hear the other panelists' views on that.
I completely agree with what Ms. Athina just said. As we are talking, ADR is considered as a secondary option or secondary choice for dispute resolution. I just want to know from the other panelists, why is that? Why is alternate dispute resolution considered secondary or as a substitute for trial? Mr. Giovanni, if you would like to continue.
Thank you. Well, by definition, alternative dispute resolution, it is alternative to the traditional courts of law for two main reasons. The first one is that most of the methods of alternative dispute resolution, like conciliation, mediation, adjudication, which is something very close to my heart and has taken over mediation and conciliation over the past 20 years all over the world, especially in construction. And then obviously arbitration, that being international or domestic, which is regulated by the Code of Civil Procedure in civil law countries. Most of these methods are non-statutory, except in few countries like the UK, for instance, Germany, Italy now, Peru, where adjudication and mediation are regulated by law, and taking a case to court without going to mediation or to adjudication will not have jurisdiction to be heard by a court or by an arbitral tribunal. So they will remain alternative dispute resolution by definition. Some of them will become a part of the legal systems of many countries because they are mandatory. For instance, in some countries, you cannot access a court unless you have gone through mediation first. A case that goes straight to a judge, he will refuse to hear it because it's not gone through the mandatory multi-tier dispute resolution, which is, in this case, mediation. And that will apply in a few cases to conciliation and obviously in many cases to adjudication. Thank you.
great to have your views. As Mr. Giovanni mentioned, mediation. So I would like to know from Ms. Veerash that a lot of legal representatives want to attend the process and want to attend the mediation. So what would a mediator do if the legal representatives want to attend the mediation?
Thank you. Well, the mediator cannot stop a legal representative from attending a mediation. In that instance, the mediator will have to prepare in the pre-mediation session, usually in the intake session of the mediation, prepare the legal representative to understand what the process is if the representative doesn't know already, and also to give them an understanding that as a legal representative, they are there to advise their client. They're not there to take over the negotiation and not be a combative person. It's a collaborative approach, it's a problem-solving approach. So the mediator needs to inform the legal representative that their presence there is not to derail the process or to hinder the negotiations. And just educate them on letting go of those adversarial tactics and strategies, and consider being a partner with the client in the mediation process. So the legal representative must empower their client while in that mediation.
Totally agreeing with you. I just want, because people want to know, because the audience wants to know, if you would like to shed light on what is mediation advocacy as a concept.
Okay, so mediation advocacy is more of giving this information and educating legal representatives or people who are not familiar with the process, even the client, on what mediation is. It's a dispute resolution process that is flexible, that is confidential, it is without prejudice, and having legal representatives understand what mediation is about as a process, so that when they are dealing with their clients, they can properly inform their clients what to expect in the process. And sometimes, if the legal representatives don't have an understanding of the process, they could ill-advise their clients that it is some sort of therapy or a soft approach. So the mediator needs to inform the legal representative, and legal representatives need to attend some forum or webinars or any information sessions that educates them on what mediation is in terms of an actual dispute resolution processes. And in some jurisdictions, as Giovanni has mentioned, it is part of the civil justice system. So it is recognized as a dispute resolution process that moves towards collaboration and reaching resolution. So mediation advocacy is more informing the clients and the legal representatives that we're here to collaborate. It's a problem-solving process. It comes with its stages. It comes with its principles.
Glad to know your views. So rolling back, my question again would be, we have such different techniques and different methods of resolving the disputes in ADR, but why? Why is it alternative? Why is it not appropriate dispute resolution? Why is it not primary? Like, what are the reasons for ADR not being primary choice of conflict settlement? That I would like to know from Ms. Athina, if you would like to.
Yeah, it is just a very short comment. Court justice in many countries is free of charge, right? Mediation, arbitration, dispute boards, all these methods entail costs, and it is for the parties participating in the dispute to pay such costs. And therefore, I think that it is a very good thing that all jurisdictions provide for systems of national justice. And in my view, this should remain the primary forum for dispute resolution in order for justice to be accessible to everyone. Now, and we can discuss further the needs of the business community and growing needs of businesses, which are not only, as I said earlier, the big international conglomerates, but even small and medium enterprises. Their needs call for quicker justice, easier negotiated solutions or mediated solutions to their disputes, justice that allows for every dispute, multiple disputes, to be resolved the moment that they arise. And Giovanni can talk to us about dispute boards in that regard in construction projects, or very technical disputes that need to go to arbitration, because we need to make sure that the arbitrator has the technical knowledge, has the time to spare on resolving the disputes. So again, my point is that there are very good reasons to go to alternative methods. There are very good reasons which explain why alternative dispute resolution is growing, but there are also very good reasons, and this is money, which explain why alternative dispute resolution is alternative.
Completely agreeing with you. If Mrs. Praveen would like to shed some light on it.
Sure, thank you. As far as it being considered secondary, I would say it's a matter of a few different things. First of all, the name itself, which my colleague referred to, education and transparency. So when we're calling it alternative rather than just a form of dispute resolution like any other form, we're reinforcing the idea that it should be considered second and courts should be considered first. I know we're going to talk a little bit later potentially about court-connected ADR, so I won't say more on that. The second issue, I think, is education, firstly, of law students. Today in Canada, we have a lot more courses on ADR, and it'll take some time for things to shift so that the law graduates are coming out of law school and providing more robust advice about different kinds of dispute resolution. On the education piece, I would also say that based on my experience explaining ADR to clients and teaching it to post-secondary students, there needs to be a lot more education of the public on different avenues the law provides for resolving disputes. And the last issue, and I think this one is really important, is transparency. Mediation agreements are generally confidential, so are settlement agreements. That's one of the things that motivates parties to choose that avenue. Same with arbitration proceedings. They're confidential as well. Sometimes you get a sanitized version of an award. Sometimes they get media attention, but mostly that's court decisions that get media attention, and that in Canada anyway are publicly available, and I'm sure in every other jurisdiction. So because these decisions and agreements are not made public and they're not transparent to people, the public just isn't very aware of what goes on and what kinds of results can be achieved. I think there needs to be more transparency so people have more access to different types of agreements that are reached or different types of arbitration awards. And of course, again, the privacy piece, that's one of the reasons people choose these avenues. Sanitized versions. In Canada, we have a free legal database that includes almost every court decision across Canada. So some sort of free, accessible, public database with any identifying information redacted so that the public could, for example, search by subject or title or keyword and just see what's available in terms of mediation and arbitration. So I would say it's considered secondary for the three reasons that I mentioned.
I do get your point. We need a lot more transparency and a lot more awareness regarding the same. And I'm sure it's very different for in different countries. As Miss Ananya is a renowned lawyer in an Indian law firm, I would like to know from her, what are the steps that particularly India is taking to increase the use of ADR?
Hi, thank you for the question. I think it's really pertinent to India itself, because India is trying to become an arbitration friendly jurisdiction, and I totally agree with all the views of my panelists as to why it's still considered an alternate. And I think that's exactly the steps which our government is trying to take to kind of remove all these inhibitions and try to make arbitration as a forefront runner. So, we've had a lot of, amendments to our act to kind of, remove all the hiccups and, try to make less intervention of court. Because I think one of the main reasons why people are probably hesitant in choosing arbitration, especially in India, would be, even though it says it's binding, the losing party ultimately ends up challenging in court. So, the mind frame is that if I ultimately have to end up in court, then why do I go through arbitration at all? I could just, file, in court and proceed there. And that's exactly what the government. So they've made like the act so watertight so that it's not easy for a party to just challenge an award in court. And another thing that, they're trying to do is to encourage institutional arbitration over, ad hoc arbitration. Because as Athina rightly pointed out, it's the expense factor in arbitration, which can be like, a deterrent, and it is expensive to do arbitration. And sometimes when you have an ad hoc arbitration, which is just under the, the Indian Arbitration Act, it could increase the costs because of, the fees of, the judges, which are the retired judges, which are usually appointed as arbitrators. So sometimes when you go to an institution, it's more streamlined. The procedure is more streamlined. It's more time bound. It doesn't take forever to do it. So that could, address that issue, which, people could have with arbitration, which is the expense factor. And another thing which, we're trying to do is arbitration is, very well known and established in various forms around the world. But the other forms, which are, mediation and negotiation, are not so taken. People usually think of it as just, something that they do off the record. It's not really considered, or they don't consider it as one of the main forms of actually settling their disputes. So, so the government is actually trying to take steps, and they've taken out this mediation bill, which kind of it gives party the avenues to mediate their disputes and actually have a settlement which can then be enforced through the court. So it's giving them more options, as the name suggests, it's alternate, but they're giving them more options rather than just arbitration, so that people would become more aware. As Praveen rightly pointed out, that people are not really aware of the intricacies of the process. So I think that's what they're trying to do, with these amendments and these new legislations that they're trying to come across. And hopefully this will actually, help in ADR not actually being an alternate and being a primary, though I'm not sure where we will reach with that, but I think it's a step in the right direction, and I think we will really make progress with these changes.
I do agree. It's a long way to go, but yes, India is definitely working on the ADR front. So, asking Mr. Giovanni, would you like to tell us a little about the mission of Dispute Resolution Board Foundation?
With pleasure. It's almost 30 years ago, the Dispute Resolution Board Foundation was funded. And it is exactly that. It's a foundation. And their mission is to divulge the use of dispute boards and adjudication in construction around the world. Their mission has been helped over the years by the use of the FDBF conditions of contract, especially prior to 1999, where the users of these international framework contracts are invited to appoint their dispute boards within 28 days from commencement date of a project. Over the years, the real use of dispute boards has moved into dispute avoidance resolution boards, because the use of a dispute board is basically to avoid disputes, because it's ideally established at the very beginning of a construction project, and they visit the site regularly, the adjudicators, whether a panel of 3 or 1, depending on the size of the project, and the agreement of the parties. And obviously they become part of the projects, and they can provide dispute avoidance through non-binding opinions. The DRBF, as an acronym for Dispute Resolution Board Foundation, over the years has strived to set canons for the proper use of the boards, as well as the proper behaviors of the dispute boards. There are dispute board members that these are highly qualified engineers, quantity surveyors, and lawyers. And a board can comprise sometimes all three of them. They provide non-binding recommendation in some countries. They can provide binding decisions, which can be enforced in arbitration. And then obviously they provide opinions which are non-binding, but normally are accepted by parties. The DRBF is very active with regions. They have 4 regions. They cover the whole world. The newest one is the South America region, which will be launched in São Paulo in May 2023. And the other regions, one covers the United States and Canada. That is region 1. Region 2 is basically Europe and the rest of the world. But from that region 2, South America will be removed due to the fact that it will be a region on its own. And then there is region 3 that is for Australia. It is a widely used in construction alternative method of dispute resolution. Over the years has provided a very good tool for parties to settle, because when there is a binding DAB decisions, the parties are required under the FDBF conditions of contract to mandatorily enter into settlement agreement discussions. And has been very successful, especially in the United States, whereby decisions have been accepted in almost 95% of the cases, with only 5% of those disputes going to court or to arbitration. So it is a very effective method of dispute avoidance and resolution. The DRBF as a foundation, it's a non-profit organization, as it should. It's registered in the United States and has almost 1,000 members worldwide. Each region provides a president-elect, a president and a past president, and a board of directors. So it's a very organized foundation, and they do educational seminars and workshops regarding the use of dispute avoidance and dispute resolution. And they obviously provide a training to become adjudicators. They have a very strong relationship with FDBF. As a matter of fact, the DRBF provides the first layer of review of future adjudicators before they are accepted on the FDBF president list of certified adjudicators. It goes from strength to strength. It's a very nice environment to be in, and I invite you to join. I'm the president of Region 2, and obviously I try as much as possible to have as many members as possible, because this is ADR at its best, without any doubt. Thank you.
It is lovely to hear about the board foundation. We would definitely like to be a part of that. So coming back to the next point, it is often said that ADR promotes settling the disputes amicably. So my question here would be, what are the advantages of settling amicably? Because a lot of people have this argument that it is somewhere, as per mediation, sometimes it's a forced compromise, sometimes it's a settlement, but in my point of view, it's it is definitely a settlement which is done amicably. So I would like to ask Ms. Praveen as to what are the advantages of settling the disputes in an amicable nature.
Okay, well, the obvious one, of course, is cost. I won't talk any further about that particular one, but with mediation, there's an opportunity to speak about the issues in a way that goes far deeper than just the legal positions that are discussed in court. The parties are involved and work in collaboration to come to a resolution, and they can and they often do create win-win situations. Even when their matter is not resolved, they generally walk away more satisfied with the process than the satisfaction level after a court proceedings, even for a party who's been successful in court. Whether it's mediation or arbitration, another advantage is flexibility of the process. It can be tailored to the dispute and the parties rather than the court procedure, which, with very few exceptions here in Canada, is the same for all disputes and all parties. For the second part of that question, can we be sure that every settlement is fair by some objective standard every time? Well, probably not. It is, however, always fair if each of the parties to the settlement has voluntarily agreed to the terms of that settlement. It's a type of contract freely entered into. With mediation, arbitration as well, but the role of the mediator or arbitrator in guiding the process is to ensure that it's balanced, and this, from my experience, ensures that any settlement reflects a genuine voluntary agreement that's fair from the perspective of each party. So our role as the dispute resolution professionals has an important impact. We have to make sure the process is balanced so that the result is a genuine voluntary agreement for parties.
So can we really come to a consensus that whatever the settlement is being, the settlement that is reached is fair to both the parties or not? Can we really say that the fairness factor of the conflict settlement is there?
Did you want me to speak about that some more, or are you asking one of my colleagues now?
Anybody who would like to share their insights. I will be repeating my question that can we really come to a consensus that the settlement reached while being an ADR is fair to both the parties or not?
Okay, I guess I'll take that one while we're waiting for everyone. Thank you, Giovanni, for basically opening the door and being a gentleman. Thank you. Well, when you're saying, is that settlement fair? We have to think, firstly, I mean, especially to students, law students, or people who are starting out in mediation or haven't been trained in mediation, we know that as mediators, and I always say this in my own training to my delegates and my students, is it's not what the mediator thinks is fair. I mean, of course, it can't be unreasonable or illegal or unrealistic. So the fairness factor of the outcome comes from the parties themselves. I mean, what do they consider to be the fair outcome? Because they are the ones sitting in that negotiation, and they are the ones who are going through the process of understanding their objective criteria, why they're making the decisions that they're making. So it's not for the mediator to decide, okay, now we've reached a consensus. The parties are the ones who come to a consensus. because it's their mediation. We've heard that it's a voluntary process, and they stay in there voluntarily till they reach agreement, or if they do reach agreement. What we need to understand is that as mediators, we give the parties fair opportunities to express themselves. So the way we practice, we hold ourselves to fair practices that allow them to speak up, that allow them to be heard, that allow them to bring perspective into the room, that allow them to hear each other. So we are the ones who provide that platform that looks as a fair and stable, safe environment for them to express their needs, fears, concerns, and interests, so that when they do reach an outcome, they consider all possibilities, and that they had the opportunity to realistically come to those opportunities. And because mediation is so flexible, we give them time to reality test their decisions or outcomes before they actually put that in writing.
Anybody else who would like to share their point of views?
If I may, again, I would like just to open up a little bit to the arbitration perspective. The question that you just asked is more destined, right, to mediation, because this is where, at the end of the day, we are seeking a settlement, a mediated settlement, but it is the parties who reach an agreement as to how their dispute will be resolved. And I very much agree with the statement that it doesn't matter what is fair to the mediator. What really matters is what is fair to the parties in the view of the parties, right? And we are certain that the mediated settlement is fair to the view in the eyes of the parties because they have reached it. Now, arbitration is a completely different beast. There is no negotiated settlement, no mediation settlement. When the parties engage in an arbitration process, they appoint an arbitrator who will be judging in law, who will apply the relevant legal principles, and we reach a binding decision as a national judge would. And here is where I would like to open a little door to say that questions of general fairness can also have an important play in arbitration. And this is especially so in cases where the parties have agreed that the arbitrator should judge ex aequo and bono, or as an amiable compositor. What does it mean? It means that the arbitrator will take into account the legal principles applicable in the case, as the national court judge would have done, but will need to make a decision after a second step. And this second step is to look at the question whether the solution brought by the legal principles is a fair solution. If it isn't, the arbitrator is free to take fairness and equity more into consideration and reach a decision which, in the circumstances, is also in accordance with the principles of fairness. And that's it, just explaining how the fairness in general can also play in arbitration more compared to before a national judge.
If I may.
Yes, sure.
Within the construction industry that obviously I represent because it's my main practice, and the use of ADR, which is the use of dispute boards and adjudicator and dispute avoidance. Generally speaking, a settlement is the best solution for all parties because it puts an end to a dispute. Fairness comes to the fact that each party has given up something, and they arrive to a reasonable and fair resolution of their dispute. If it would be unfair for one party, there would be no settlement agreement, and that will move on to arbitration or to court. So the word settlement and settlement agreement in construction is the best thing that can happen. And the use of dispute boards works in that direction because as part of our avoidance techniques that we use, we foster settlement. We provide opinions which make the party see aspects of the dispute that they have not taken into consideration, but open their minds that if they go further with their line of thinking, they may get a decision, a binding decision that may be against them or in favor of them. And this creates that moment where the parties really stop and start talking. And in some cases, when this is done earlier on, during construction and not after the fact, it's very effective because obviously a construction company, a supervising engineer, and an employer in whichever country, they have only one aim: successful completion of the project for the benefit of all parties. So if they see a possibility to settle with the help of a professional, that they will take it, because on the long run, it will make a lot of sense. Thanks.
So definitely it's a great step towards the awareness and being fair, being transparent at the same time. So going by one, I would start with Miss Ananya again about arbitration, as she specializes in arbitration. So the audience would like to know, what is the difference between institutional and ad hoc arbitration, and which one would you recommend? And later we'll come to mediation and so on.
Thank you. So, I mean, my experience with I think I'll answer the second question first, and then I'll probably come to why I would recommend one over the other. I think in my experience of both ad hoc and institutional, I personally think that institutional arbitration is definitely a much more effective process of dispute settlement over ad hoc arbitration. And there are a variety of reasons, why I say this. Simply when you have an institution who is basically, conducting your arbitration, that, there is a timetable established. It is much more effective because there's an administrative support by the, secretariat of the institution. So any follow-up which is to be done, say with the arbitrator, between the parties, it kind of takes a lot of load off, the parties in the council, and that makes it more effective for them to concentrate on, the merits of this dispute, whereas the arbitration is conducted by the institution. It's also, parties generally have a more better sense of the cost, because institutions normally have a schedule of fees. So it depends on, the claims that you're making. So you can foresee how much, each party will spend. It may not be, completely to the T, but it's a better estimate than an ad hoc arbitration, where you may start with thinking that you will spend X amount, but you actually end up spending Y amount, and the disparity between the X and the Y is a lot. So I think when you go through an institutional arbitration, you have a much better, sense of the amount of costs which, the parties will be spending, which is, one of the major factors, which influence the choice of arbitration, as we've already discussed earlier. Another very big advantage of institutional arbitration, I feel, is the choice of arbitrators you get. For someone who may be, for whom it may be their first arbitration, I think the institutions give a bigger pool of arbitrators with maybe specialized knowledge of the dispute which you have. So they could probably suggest you a better arbitrator, or, you have the option to selecting an arbitrator in that particular field. Whereas my experience with, ad hoc arbitration is usually parties end up, at least in India, they end up appointing that, retired judges of the courts, or, just advocates. Specialized, experts are not usually appointed in ad hoc arbitrations, which may be different with institutional. And that may be effective also in, some other way. Another, aspect of institutional arbitration, which I think can be useful, is the concept of emergency arbitrators. I think the speed at which they provide interim relief really caters to the need of the party at that point of time, which may not be present in ad hoc arbitration, even though you have the option of going to the court and, getting interim relief before a tribunal is appointed. I think emergency arbitrators, or the concept of emergency arbitrators has received, much acceptance and, the appreciation that it does deliver the speedy relief that is required. So I think that's also another important, reason why I feel that that's, institutional arbitration is preferred over ad hoc arbitration. And one last point is that usually when you go through an institutional arbitration, the institute kind of scrutinizes the award before it comes to you. So I think, that kind of minimizes at least the, the corrective or the interpretative challenges that could, come at a very nascent stage. So they kind of filter the award and they try to get you at least, the perfect award, which probably may not be challenged in court. So I think that added level of scrutiny also kind of, goes to their advantage and, why I think institutional arbitration I would prefer. And I think even generally the trend is, or, the vibe is that institutional arbitrations are more preferred than ad hoc just because of the structured manner in which they function. And just because of the, the more ease of functioning in arbitration, and it really helps parties to actually, achieve the aim of arbitration, which is a speedy justice and, within the time bounds and, like the cost limit. So I think that's why I feel like institutional arbitration is preferred over ad hoc, and that's my personal preference as well.
So we have a really good question from the audience that can mediation and arbitration be combined? And as Ms. Athina is an expert in the field of arbitration, and Ms. Veerash is an expert in mediation, I would like to know as to can mediation and arbitration be combined, or I can put it in a different manner, how can we combine arbitration or mediation and other ADR methods?
Veerash, happy to start, but if you want to, okay. Well, I'll be discussing from the point of view of an arbitrator. The typical way that we see mediation and arbitration be combined is that the contract in itself provides that at first the parties shall attempt to engage to reach a mediated settlement. So the parties have a duty to engage into mediation proceedings, and only if the mediation does not have an effect after a specific time limit, after 2 months or something like that, does one of the parties have the right to initiate arbitration proceedings. This is the kind of typical situation that I have seen as an arbitrator in various contracts, which means that when parties come to me to resolve their dispute, they have, in most cases, tried already to reach a mediated settlement. Has this been an effective attempt, a real attempt to reach a mediated settlement? I can say not always. Sometimes, and that's quite unfortunate, the parties will consider mediation just as a necessary step, kind of a formality, a box to tick before they engage into arbitration. And we see when we check the file that there has practically been just a letter by one party saying, I'm happy to engage, to initiate a mediation. The other party does not respond. And then the parties go to arbitration because the condition provided for by the contract has been met. Why is that so? Because parties may not wish to engage into mediation at the beginning of their dispute, or after having already tried to reach a negotiated settlement unsuccessfully, because they don't want the other side to know more know a lot about their position in the dispute before this goes to an adjudicator, to an arbitrator. Now, another approach that I use as an arbitrator is to invite the parties after the first exchange of written pleadings to set up a window for mediation. What I do is that at the very beginning of the arbitration proceedings, when we set the procedural calendar, I'm the one suggesting to the parties that if they see no disadvantage to it, if they don't have any argument against it, we can fix at least a month window or a 2-month windows after the first exchange of pleadings, during which either party can take the initiative to invite the other party for a mediation. And sometimes this can be effective. Why is that so? Because at that stage, the parties know better the position of the other, of each one. The parties have had the chance to discuss with their counsel and see that the other party, the other side, also has arguments that may be valid. And because the initiative for launching a mediation process actually comes from the arbitrator. So there is no pressure to each of the parties saying, if I am the one inviting my opponent to a mediation, this may be considered as a weakness by my opponent. Well, just to say that this is another alternative and it works, and it is for the arbitrator to take the first step and suggest such a mediation proceeding. Of course, the arbitrator should not be, at least in most of the jurisdictions, in France, the arbitrator should not be involved in this mediation. And all that they can do is suggest give a couple of names of mediators who can assist their parties in reaching a solution. Does it work always? No, it doesn't. Sometimes the positions of the parties are polarized, and the parties just do not feel that they would like to attempt a mediated settlement. But it is at least a good opportunity for the parties to reach a settlement quicker and at a lower cost. And Veerash, happy to hear your views on that.
Thank you, Athina. If you don't mind, Vanshika, I'm just going to go straight into it. I agree with what Athina has said, especially I like that you touched on the tick box approach, because as mediators, that's what we struggle with in practice. A lot of clients come to mediation, most of them, because their legal representatives or lawyers have instructed them to come there, so it looks nice on paper if they were to go into an adjudicatory process. And so that tick box approach appears, and we see them. What we got to be careful of is, though, that they're using mediation as a fishing expedition with, like Athina says, they're using it to collect information that they could use it outside of the mediation. And I think that's where in some jurisdictions, they allow the mediator and the arbitrator to be the same person. And it becomes difficult in those proceedings where the arbitrator is privy to confidential information shared in the mediation. So you've got to look at the policies and procedures and the rules and regulations that manage a mediation arbitration hybrid process, or an arbitration mediation arbitration hybrid process, because of that sharing of information. Yes, both processes do have that confidentiality around that environment of both dispute resolution processes. But we've got to be very careful how the clients and their lawyers are using the processes. Because in some instances where there's policies of saying, let's use arbitration to narrow down the issues and then use mediation as a negotiation environment to reach some sort of agreement, and then use the arbitration process to put that into writing and to cement it. Be careful that the information being shared in that mediation or collected in that mediation then gets used in the arbitration against one or the other clients or disputants. So it can be used if it's used effectively and in good faith. And that's what we usually say to clients. We're not using mediation as an abusive process to get settlement in arbitration or in litigation, or to extrapolate information. And we do have case law out here in South Africa that defines that the information shared in mediation remains confidential. So in that instance,
typical approach of arbitrators. This is the typical approach of arbitrators when we invite the parties to resort to mediation in the context of arbitration proceedings. The idea, and that is really what I have only seen, this is the only thing that I have seen in practice, is to tell the parties that the documents exchanged in the course of mediation will not come back to us. We will just be informed of a settlement, if there is one, and of a new terms of reference if the dispute has narrowed down to specific issues after the mediation. Sorry for that, but that's in accordance also to with my experience.
And Athina, that's summarizing the benefits of using mediation prior to arbitration, because it does use the process to narrow down the issues. The clients get to vent. In mediation, we deal with the emotions. We get to understand what's underlying this conflict between them, and then send them off to arbitration to then get an outcome that they can hold to each other. Because as Ananya said, mediation is not popular because sometimes it's just a memorandum of understanding. Then it's not binding. It's a voluntary process. So yes, so mediation and arbitration can be used together, but I think the way we explained it, it should not be used at the disadvantage of the clients.
If I may, I have a different opinion. I'm an international arbitrator, and obviously don't believe that mediation arbitration can intertwine and basically coexist with one arbitrator taking the role of mediator and then arbitrator. We made very clear this in the use of dispute avoidance adjudication boards, that mediation is not to be used at all. And what the adjudicator will do, it will meet always with both parties, and it will avoid and is not allowed to meet separately with the other parties, because that can jeopardize no matter what. If there is no agreement and the dispute adjudication board will have to give a binding decision, which may become finally binding as well. If we look at ADR in generally, these are creatures of contract. They're private and they are at law, always conditions precedent before a party can access to arbitration or court. So I see them as separate issues. What I do sometimes as an arbitrator, I just revert to the order that Athina has so eloquently explained. I will ask at the beginning, before the party exchange, if there is a possibility between the parties to come to an agreement, and then I will put the arbitration in abeyance. But that's as far as I go. Thanks.
So as we are short on time, and I wish we weren't, but there are a lot of questions coming from audience, and the first one being, what is the fundamental need of ADR? If somebody would like to answer, starting with Mr. Giovanni.
Thanks. Well, what alternative dispute resolution does, it just creates a first tiers of dispute resolution with the aim to avoid legal proceedings taking place, which are lengthy and costly. It is cost effective. If we look at the use of dispute avoidance adjudication boards, they cost anywhere between 0.02% of the cost of a contract, so almost inexpensive. Whilst arbitration can become seriously expensive, especially if the quantum is quite large. So it has obviously a cost and time efficiency value that is there to avoid the lengthy proceedings through litigation or arbitration. Thank you.
If Miss Praveen would like to add something to the same question, I'd like to repeat the question again. What is the fundamental need of ADR? And since she's a founding member and she has a very well-renowned organization, I would really like to know the fundamental need of that.
So I saw the question in the Q&A, and when the question is posed, what is the fundamental need of ADR? You know, perhaps the person could clarify the question a little bit, like what do we fundamentally need for ADR to work? Is that the question, or why fundamentally do parties need ADR? I think I'll answer the second one first, if that's what the question meant. With ADR, for the parties, if it's so the two separate ones, if it's mediation, it's not just resolving the dispute. Sometimes you can rebuild relationships, and I've had that happen where it could be people in business together, it could be neighbors, it could be family members, because they're working together, because they're resolving something together, they can create more positive impact. So that's one of the aspects. And then I might ask the person to clarify the question as well, just because which aspect is fundamental referred to. But with arbitration, the fundamental need for parties is to give them an alternative, something that's private. One of the things we talked about, Giovanni talked about, and I believe my colleagues have as well, is we talked about cost and whether it's available nationally. One of the things this relates to educating the public about ADR, about arbitration. It's cost effective. There's been a bit of a trend from what I've seen, to add procedural steps to it, whereas arbitration was originally designed to have procedural steps than court proceedings, and it might be that lawyers or parties agree to adding more steps into arbitration. Some of my colleagues can speak to this for other jurisdictions, but we need to sort of, as far as in North America, sort of look at when and why are to integrate additional procedural steps into arbitration, and whether that's just because of the lawyers being familiar with and comfortable with the court process, or whether it's because there was some sort of analysis done about whether the additional procedural steps are needed. So fundamentally, parties need ADR because it will give them more efficient results. It can be cost efficient. As I said here, it's there's a bit of a trend. It's not always as cost efficient because of the additional procedural steps, but that's something that needs to be looked at, just the way that it's developing. So I might have gone a bit expansive in my answer, and that's partly because I'm not fully clear on the question, but hopefully I've answered it, and if someone's got a follow-up question, they can ask.
I guess we did understand your point of view, and I really appreciate it. The next question would be, how does one prepare clients for arbitration or mediation? And I would again ask you to answer it because I really think that you're the perfect person, and of course others also, but you can definitely start first.
Okay, so how do you prepare them? I'm going to start with mediation. So the way I prepared my clients when I was acting as counsel is slightly different than how I prepare the parties when I start a mediation. So as counsel, I prepare the parties by setting out exactly what litigation would cost. And that means the steps that are left, the unknowns, the hours, the hourly rate. I would, as counsel, have them look at what is your best case scenario, like what is the best outcome you can get in court, what is the worst outcome you can get in court. If I can give them probabilities, I would do that. My background was all commercial litigation, so I had clients that basically understood cost and risk and were able to sort of make decisions on that basis. There's the well-known concepts of WATNA and BATNA, which is analyzing your worst case and your best case scenario. I would do that before mediation or any settlement discussion. When I'm acting as mediator, I do something a little bit differently. And I talk at the beginning about, and even if I'm preparing the parties in advance, like if we're meeting together, everybody, and then I do one prep meeting before the actual mediation, if that's the procedure we're following. Either way, I spend time preparing the parties to think about how they're going to speak when they're at a mediation. And it's really important to convey the concept that you need to speak to people the way that you would want to be spoken to. So the words you use, the phrases, how would you feel if you were on the receiving end of that? And as far as listening, some sort of conversation at the beginning about listening attentively, which means you're trying to understand where the other side is coming from, because you need to understand exactly where they are and why if you're going to try to convince them of anything else, which is what the mediation process is. Being respectful, not interrupting each other, some basic kind of ground rules. And these things sound really simple, but they actually in practice go quite far. And if you practice that, people will mirror it. And if I'm preparing parties separately, I tell them that it's just human nature. We mirror behavior. So kind of almost teaching them the basic guidelines for mediation in advance. Sometimes it's just also about, if, for example, I'm also a mediator with the Superior Courts in California, and in California, the judges can send parties to mediation, and sometimes, you know, I have to just get them to at least start having a conversation, because they can be referred to mediation, but they don't have to have a conversation. But they generally do start, and some of the phrasing can be like, well, you're here. The judge isn't going to hear you yet anyway. So if we're in this room for the next hour, you might as well try talking about it. And that generally works because they're there anyway, and court-imposed mediation process works well. I think one of my colleagues said something about proposing mediation and it potentially looking, I think that was Athina, it potentially looking weak. As counsel, I never thought of it that way. And as a mediator, I don't think of it that way. It opens a door. It's opening to communication. And in fact, if you're the one who suggests mediation, you know, sometimes it doesn't hurt you to, it's not waving a white flag, but it's showing some ability or willingness to bend. And speaking of like sort of mirroring behavior, like human nature, it will help them as well. You'll make it easier for the other side. And it could have the opposite effect. Oh, that person asked for mediation. They're being conciliatory. I will be also. Also, if you're counsel, when you're mediating, I don't know all of the rules in other jurisdictions, but in Canada, we can't talk to the other party if they're represented. We can't talk to them directly. We can only talk through the lawyer. The only communication I can be sure always gets to the client on the party on the other side is if I send a settlement offer. I know the lawyer has to send that to their party. So that's the only way I can communicate sort of directly with the party on the other side. If you're at a mediation, not using it as a fishing expedition, but if you really build your case, you prepare the BATNA and WATNA, the best case and the worst case scenario. You prepare for the case in as much detail as you can. You go to mediation, and when you're all in that room together, sometimes parties get separated, sometimes they don't. That is your only opportunity, and it is a great one, to talk directly to the client on the other side, so the opposing party. The lawyer will be there, but you can talk to them directly, and it's not about intimidating or anything like that. It's just presenting the case as best you can. So that's on the mediation part, how you prepare, whether you're counsel or whether you're the mediator. For arbitration, it's slightly different, that procedure. Obviously, it's different, and it's different from court, and it's meant to be efficient. I talked earlier about there being more procedural steps, generally speaking, in court versus what arbitration was meant to be. Whether you're the arbitrator or your counsel to parties in our arbitration, based on what I've seen here in North America as far as how efficient arbitration proceedings can be and how sometimes procedural steps are added, the biggest thing I would say is think carefully about which procedural steps are necessary, and even think, sometimes you're doing the procedural order at the beginning and you might be asking, okay, how many days is this hearing going to be? The question to ask before that is, do we even need a hearing? If it's a commercial dispute, if there's contracts, if there's documents, there are scenarios where the documents speak for themselves. They don't change. They don't lie. You can quite often look to the documents for answers and just get submissions from parties. It's a way to ensure that the arbitration proceeding is efficient. I don't know. I'd love to hear from my colleagues about how this works in other jurisdictions, especially Athina. She seems to have lots of experience, particularly in that, and maybe Giovanni as well. But, kind of getting back to arbitration was intended to be both sides put their best case forward. Those materials are exchanged, and then each side has an opportunity to respond. And I think regardless of the monetary value of the arbitration, so even if it's a huge monetary value, it doesn't mean it necessarily requires more steps. It could just be, you could just have a very streamlined procedure for that as well. I realize I went on for a while. The mediation part I'm really enthusiastic about, so I might have said too much, and I do apologize for that. I do want to hear from my colleagues. I'm very curious if they have anything to add, if we have time to discuss this topic.
Definitely. As rolling on the same page, as Ms. Praveen said, that it is sometimes very hard for parties to start a conversation, or for mediators convincing the parties to really have a conversation, just to start that tad bit is very difficult sometimes. As Ms. Veerash is in the same field, please, I would really like to know your views regarding the same.
Well, regarding starting a conversation, can I talk on that one? Because I think we've been through the advantages and the disadvantages and the needs and the processes in detail or elaborately in this conversation amongst all of us. So I think starting the conversation and part of preparing the clients for mediation, we use the process of getting them to give us their opening statement, or just giving us a brief introduction of why they are in this dispute. So it depends, on the level of conflict and level of communication between the clients and the disputants. You can have them in the same mediation where it's a joint mediation session, and using that opening statement and using that process of getting them to tell us what the dispute is about in their own words, that starts the conversation going. It also empowers them to feel heard. In some instances, if there's a power imbalance in that mediation or in that relationship between the clients, and one of them usually does all the talking and the other one doesn't usually do all the talking, they're quite reserved or afraid, if there's a fear factor in terms of speaking up, we use that opening part of the mediation process to hear their voice. And that gets the conversation going. And of course, as a mediator, we are then able to evaluate, what do we continue with? Are they comfortable conversing in the joint session? We continue if it's effective and constructive for the process, Or we can use the caucus sessions or the individual sessions where we separate the disputants of the parties, or we have different sessions for them where we engage with them to get them to start communicating with us as the mediator. And that helps us understand why they're in this dispute, where they are in this dispute, how they feel about each other, how they feel about what their outcomes or prospects of outcomes are, where they're evaluating their prospects of success in the mediation or their alternatives outside of the mediation. So the conversation in getting the clients to speak in mediation really boils down to the communication skills of the mediator and getting those clients to open up and talk to them and developing a trust relationship with those clients. So having that relationship with the clients also gets them to communicate inside that mediation and gets them to learn how to communicate with each other.
Well, agreeing to what you said, I guess things are different for different procedures. So for mediation, it's a little different. And at the same time, for arbitration, it's a lot different. So coming back to Mr. Giovanni, how is it different for arbitration? And at the same time, when can the enforcement of an arbitral award may be refused or gets refused by the courts? If you could shed light on that, because our audience from LinkedIn is asking these questions. So if you would like to answer this question.
Thank you. In arbitration, the awards are finally binding on the parties in normal cases.
Audience from LinkedIn is asking these questions. So if you would like to answer this question.
There is very few possibility to set aside a final award in arbitration. And normally the institutions that will be looking into it will look at only procedural matters, especially in international arbitration. If there have been some breach of procedures, then an award could be set aside. Normally, all jurisdictions allow for parties to use the local courts for the annulment of an award if it meets the breach of procedure, certain requirements in the law of that country. It is very difficult to set aside or annul an award, almost mission impossible, especially in institutionalized arbitration, like, for instance, the ICC, International Chamber of Commerce, where they do scrutinize an award before the arbitral tribunal can publish it. And they will look at enforceability, whether it can be enforced, whether it's procedurally correct, whether or not there is a breach of natural justice. And in doing so, they obviously provided a points of views to the arbitral tribunal. And sometimes the arbitral tribunal revises certain parts of the awards that, in the view of the institution, in this case the ICC, it could be ground for a challenge. There is, as I said, very little ground to set aside an award because arbitrators these days, especially in institutionalized arbitration, are highly professional, and they will provide equal representations. There is no way that a party can be heard and another will not. However, there can be situations where a party wishes to be silent and the arbitral tribunal will have the right to proceed with the arbitration with one party not participating, providing is offered at all times the possibility to submit pleadings and be part of a hearing. When it comes to using the national court to set aside an award, the judge will not look at the merits, never. It will only look at procedural misconduct. However, if it's a domestic award, in some jurisdictions, if the judge sees that there is a matter of procedural misconduct, after that he can actually look into the merits of the matter, and that becomes very difficult. For instance, in some civil law jurisdictions, that is allowed. Thank you.
That's great to know. At the same time, I would like to know Miss Athina's view.
Just to clarify, my view on what?
I would like to repeat the question again.
Oh.
When can the enforcement of an arbitral award may be refused by the courts? And
Okay.
also how the approach of preparing the client is different from mediation and arbitration.
Okay. Well, perhaps just to clarify at the beginning, even though I think that my colleagues have dealt with these questions very ably already, but so that you can hear my voice. Effectively, preparing a party to arbitration is quite different from preparing a party to mediation, because the process is quite different. The advantages of arbitration are different than the advantages of mediation, and the reasons for resorting to arbitration are different. The classic example where arbitration is useful is where parties come from different countries, are of different nationalities, and they want to have a neutral forum for resolving their dispute. They mistrust the national judge, one of the other, and they prefer to go towards a forum that would not risk being biased in favor of their own national. Arbitration also provides for a possibility to keep a dispute confidential, to have a dispute decided in a different language than the language of the national judge. And often we see even arbitrations where documents in English, in French, in Arabic, in different languages can be used without a translation, which renders the decision-making more efficient and the process more efficient. Arbitration, one pays their arbitrators, and the duty of the arbitrators is really to get to know the disputes very, very well, which means in practice that for complicated disputes, arbitration may be a very good solution, because the arbitrator will look at all the documents, will check the case, will study the quantum of it, etc., etc. So by main way to prepare a party for an arbitration is to explain to them what the dispute is like, to tell them, because they should know that it takes a lot of client time running an arbitration. They need to find out relevant documents. Arbitration proceedings can be quite intense, voluminous, etc., and they need to prepare for that. On the other hand, it's not. There are certain characteristics of arbitration that are different. Advocacy in arbitration can be quite different also from advocacy in litigation. There is less an element of surprise that we can see in litigation. In arbitration, each party will be given, if not a full opportunity, at least a very reasonable opportunity for its case to be heard. There are no surprise pleadings coming a day before the hearing or after the hearing and left unanswered and things like that. I think that I have discussed a lot this question. With regard to the other question of the possibility to resist enforcement of an arbitral award, I very much agree with what Giovanni has said. It is possible, but the possibility is very limited. Awards are set aside or enforcement is refused where there is a big issue, a big procedural problem in the arbitration, where a party has not been granted a reasonable opportunity to hear, to present its case, and that is quite rare in the circumstances, or where the decision itself violates like the most important principles of law, there is a public policy violation, as we call it, or an arbitration deals with something that cannot go to arbitration, a criminal law issue, for example. The arbitrator cannot sentence a party to jail or something like that. But apart from such very specific, very limited grounds to resist enforcement, an arbitration award is like a very good passport, right? Like a Swiss passport. You can use the award and enforce against the losing party in 160 jurisdictions around the globe, in the majority of states. So you can seize assets of the losing party around the world with the same arbitral award. And I stop here. And thank you very much.
Great insights from you. Coming to the next question, I would like all the panelists, what problems does one face while resorting to dispute resolution process? And coming back to my question, what I would like to ask all the panelists, please share all the challenges a moderator or an arbitrator faces, and what are your good coping mechanisms as well as best techniques or best experiences, at the same time worst experiences. I would like to start with Miss Ananya, if that's okay.
So, unfortunately, I haven't yet, sat as an arbitrator or a mediator, so I probably wouldn't be able to, shed much light on your second question, which is, what are the issues which are being faced when you're an arbitrator and your coping mechanism. But maybe I could just, circle back to the previous question if you, and just add a short point as to the challenges to an arbitration award. And Athina mentioned, and even Giovanni mentioned, that there are very limited possibilities, and I totally agree with it. Just one thing, which I wanted to add is the whole argument on public policy. While the term seems very straightforward and, it's the whole concept is that, the challenge has to be limited, but the interpretation of this word, public policy, has led to such, I think, at least I can speak in the jurisdiction which I am in India, there are like umpteen number of judgments, which are interpreting as to how much the court can go into when it's, it's dealing with public policy, and as to what are the facets of public policy. And this was one of the main reasons as to, one of the, I mean, I don't want to call it a drawback of arbitration, but it was one of the reasons why, parties were a little hesitant, because the interpretation of the scope of public policy. And the recent amendments have really tried to, tie it down and, kind of restrict this interpretation and to, bring it in line with all the foreign, jurisdictions, so that the court is not really able to, do a reappreciation of the merits or the evidence. So I think, this particular ground of public policy is open to a lot of interpretation and, has gone through quite, some stages of, from a wider interpretation to a narrower interpretation. So I just wanted to, add that one point, and maybe my panelists fellow panelists will be in a better position to answer your next question on, the coping mechanisms of being an arbitrator and mediator. So over to them.
I would really like to know the other panel member views.
I can speak a bit about that. Problems of ADR and coping mechanisms and techniques with, I'm going to talk a little bit about arbitration and a little bit about mediation. With arbitration, I can think of a couple of proceedings where I was acting as the arbitrator. And I still remember the first one where one of the parties was late with its submissions, which means that they're more than late, the deadline passed and they hadn't submitted anything, and it was a documents only arbitration, so expedited procedure. And as the arbitrator, you've been appointed, you're engaged, one side had submitted materials and the other isn't. It's a difficult position to be in. You want the others, you want all parties to submit their documents, to submit their arguments, so that you feel legitimate in the decision that you're making. And I remember it really vividly because it was the first time that happened. And prior to that, I was always counsel and in commercial litigation files. And I can think of scenarios where the other side was late and then late again and late again. And, you know, I'm kind of in court with my hands on my hips, like, okay, we should be able to get some sort of decision or ruling now because they haven't complied. And, you know, sometimes the other party would be given another extension and maybe they had to pay some costs or something. But I really understood the position of a judge and why they gave the extra time. And I had to give this party extra time as well, because that giving them extra time and having them submit their materials is a far better scenario for everyone, including myself as arbitrator, than ever having to proceed with one side not submitting everything that they wanted to submit. And it goes back to what my colleague was saying about procedural fairness as well, and kind of some of the basic requirements for just a fair and balanced process, even if that means giving them extra time. So it was interesting to be on the other side of that, and I had to do exactly what I've seen judges do many times. Another scenario, and this was with arbitration as well, there was a fairly significant sum at stake, and one side was more sophisticated. They were doing this without counsel, and the other side was less sophisticated and also handling it without counsel. You can't give anyone legal advice. You can always tell them that legal advice is available or what resources are available, and you're hoping they engage that on that particular file. If it was client of mine or a friend or a family member, I would have ensured that they had representation. So that's another scenario where it can be sort of problematic, where if it's imbalance in terms of sophistication or who's represented and who's not, and you can give people information, but then after that, it's up to them to decide. In the example I just gave, the party that seemed less sophisticated than the institution represented themselves, and ultimately it's their decision. With mediation, I did my training with this amazing prof at Berkeley in California, and she taught us something, and I've applied it in my practice, and I think it's worth mentioning. With mediation, we're dealing with all kinds of different problems of people. We're encouraging the parties to listen to each other. As a mediator, we're holding a very vast space to receive all of the information that they're giving us and all of what they're expressing on a human level, which sometimes is related to the dispute in a way of it being material that you would cover in court or in arbitration, and sometimes it's completely different things that human beings need to talk about. So you're holding this space, and it's really important as a mediator after that to ensure you do whatever it is you need to do to release that, because there is I don't know how else to phrase it, but there is it's not really an exchange of stress, but you're definitely taking on some of the emotions or some aspect of the problem. So it's just after certainly, it's just important to be self-aware and self-regulating. When you need breaks, when your own views might be coming in, when you've had a very hard day and a long mediation, maybe you've settled, but just kind of taking the time to do the self-care, especially on the mediation side, because what you're doing as a professional in that field is quite different than the arbitration. So again, long-winded answer, but hopefully the information is helpful to the listeners.
Definitely, we gained a lot of insights. I would like to ask Ms. Veerash the same question. Any best or worst scenarios or experiences while mediating a conflict?
Ooh, lots. I think over 10 years of doing this, there is no one answer. And I think all my colleagues here will say there's not enough time to actually express to the audience everything that we go through in each of our cases of whether it's mediation or arbitration, even if it's just a consultation. I'd say for mediation, the best part of it is when you see the transformation of the relationship. So when they come in there quite adversarial, not on the same page, really thinking that you're going to give them all the answers as the mediator, and then they start to understand what the process is, they start to understand your role and your function, and then they start to understand that actually the decision comes from them and not from you. You start to see them applying their minds to the process, using the process effectively, and applying their minds to the actual problem. And then they wade through it to say, okay, this is necessary. This is really an unnecessary petty argument. It's really holding us back from reaching agreement. So when you start to see that transformation in the clients themselves, or the disputants, you as a mediator, you understand how beneficial that process is to it. I think the worst thing to think about as being in the mediator's seat is it really isn't, you really have to change your mind from thinking it's a win. It's a win for you if the parties reach an agreement. It's a win for them. You really have to remove yourself, that aspect of where the mediator has no vested interest in the outcome. You have to, as the mediator, understand that this is the party's process and the outcome belongs to them. So as they are moving through the process, you need to understand that from a mediator's perspective, I shouldn't be controlling the win. The win belongs to them. So you cannot be influencing that outcome. And that's where, as a mediator, you need to hold yourself back from taking control over that decision that they have to make. So your biases in terms that you bring into it, and all of us do, we cannot be completely unbiased in this. We have to be very aware of it. You have to work on it as a mediator from day one or the first day you attend training to right now and beyond. You, as a mediator, you're constantly learning. We always talk about in training about the mediator's toolkit or the mediator's toolbox. And those are the techniques that you keep adding on to your practice as a mediator. So coming on to the techniques part of being a mediator, you add on to that as you learn, as you develop. And one of the benefits of being part of a mediation community like we all are, and I'm sure all of us are outside of this webinar, is that we have mediator colleagues, we have mediator friends, we have mediator people that we have gone through the ranks with, whether they are mentors or whether they are our colleagues. We learn from them, and what we do, and recently I spoke about this, is we create a support structure, because as mediators, we're seeing a lot of things that sometimes might question our capabilities. And we need to have a support structure. We speak to like-minded people, like-minded professions, and say to them, you know, I was in this situation with this mediation, of course, not breaching confidentiality, is saying, as a mediator, this is what I had done. What are your views on this? So developing a support structure of people you can trust in your profession as a mediator, as an arbitrator, to bounce off practices and techniques and skills, developing that. I think also one of the things that we benefit from as trainers of mediation is our people that we have training. When that light bulb switches on for them, when they realize what mediation actually does, I can't speak too much about arbitration. I can speak about training in mediation, is that light bulb moment that my delegates and my students go through when they do that mind shift into understanding exactly where you sit as the mediator. And suddenly they understand what perspectives are. Suddenly they understand what that transparency is, what that good faith is, what that communication is in that mediation. So for me, I think those are the best parts of that being mediation. The ignorance part of what mediation is and using it as an abusive process, that's I would say that's the negative of it, is not fully understanding why mediation exists. and how it is beneficial to bringing out the interests of the parties. So for me, that's just the negative part of it, is when representatives or lawyers use it in a negative context, which it isn't, because it always sits in a place where we give people opportunities to express themselves. So for me, that's my contributions towards mediation.
Great to know that. Coming to the last question for this conference, a question asked, a really interesting question asked by Tanya. It says, are there any set rules or a procedure when talking about neutral evaluation? And I would really like to know Mr. Giovanni's view on the same.
Thank you. Well, discussing first adjudication and the use of dispute boards, the conditions or contract that FDBF provides, it provides also the procedural rules that the dispute avoidance and adjudication board shall have to use, and obviously they cannot breach. The rules in the 2017, the second editions of the FDBF suits or contract has been extended quite a bit. And then the parties empower the dispute adjudication board to augment those procedures, because the DAAB is empowered on his own to decide on his own jurisdictions and in the best way to act in the event that the referral of a dispute is submitted to the DAAB. So it's very much procedurally structured. As an arbitrator, obviously, if you deal under ICC rules, they use a French approach of terms of references, and that in the terms of reference there is the remit of the arbiter tribunal, and it cannot go beyond that, because that could put at risk the award. An arbitrator cannot decide on a matter that has not been referred by the parties to the arbiter tribunal, and he cannot exceed his jurisdiction, because that will be fatal errors. The same thing, an adjudicator, a dispute avoidance adjudication board, if he's dealing with a dispute, it has to be very careful, because although one of the rules in the FDBF conditions of contract that the arbitrator, the adjudicators, has inquisitorial power, well, that is a double-edged sword. It has to be used with experience, because you cannot obviously wander on matters that you don't have any jurisdiction to deal with it. So it's pretty much always procedurally orientated. Both the methodology of expert determination, dispute adjudication, as well as arbitration. Regarding mediation, which I follow quite often, obviously there are rules, there are ways of dealing with it, and my colleagues have eloquently explained that. Thank you.
Thank you, Mr. Giovanni, for your thoughts on this question. Ms. Athina, if you want to address the same question and share your thoughts.
Yes, in a nutshell, I mean, the neutral evaluation is similar to expert determination in that what happens in such a circumstance is that we are in the presence of a very technical dispute, and what the parties need is a person with expert knowledge of the field, with technical knowledge, to assist them in resolving the dispute. Now, it's not mediation. There is no agreement reached by the parties. It is close to arbitration because it is a third party giving a decision on the matter, deciding the dispute. It is faster because there is no lawyery things. It's just one person with technical knowledge giving the solution to the dispute, but it doesn't have the advantage of arbitration, of a binding decision at the end of the day. What you have at the end of the day is an expert giving their opinion of the issue. But then it is up to the parties to decide whether they would like to abide by that decision or not. And I hope this is clear.
Thank you, Ms. Athina. Thank you for sharing your thoughts. With this, we come to the end of the webinar. So I think it was really an amazing panel, and thank you for all our attendees who joined us here on Zoom and LinkedIn and YouTube channel. And I think our audience have gained some really valuable insights today, and it was really an informative session. So yeah, World Law Alliance is really happy to have had you all here today with us. And I would also like to, announce that World Law Alliance is also coming up with our annual flagship conference, which is WLA 2023 Dubai next year in April, which is 26 and 27. So we'll be having various themes, and international arbitration and mediation conference is one such theme around which we'll be having a international conference. So we have a lot of speaker and partnering opportunities available for everyone out there. So if you're interested, you can always write to us at gayatri@worldonalliance.com or contact@worldlawalliance.com. So yeah. Thank you all once again for taking the time to join us here. And it was lovely having you all. Thank you so much. And you can always access the live recording of this video on our LinkedIn and YouTube channels, World Law Alliance page. Thank you. Thank you, everyone. Have a good day.
Thank you very much.
Thank you.
You.